Hello, my name is Christie Arkovich, and I am an attorney here in Tampa, Florida. I wanted to talk briefly about how student loans are no longer a millennial problem. I know a lot of folks think, this is a problem for 20 and 30-year-olds, but, more and more our clients are 50 years of age or older. In fact, I wrote a chapter on a book, Elder Care 101, that is coming out the end of this month. I think it's July 21 or so. I'll have some more info in the blog about this. But essentially, we did a chapter on how to deal with financial student loan debt that someone might still have in their 50s, 60s, 70s, and yes, even 80s, believe it or not. And there are effective ways to get rid of this debt in a tax-free way. And to basically be able to enjoy retirement and not have Social Security garnished. One of those ways is, in fact, the new student loan discharge provisions for bankruptcy filing. And I just wanted to go over real quick a question that is asked in the new attestation process, because it lets someone describe situations that might apply when they're older, and things that may help them get a discharge and be done with once and for all these loans. And so this particular question, describe any other facts indicating that you have acted in good faith in the past attempting to repay the student loans that you are seeking to discharge. These may include efforts to obtain employment, maximize your income, or minimize your expenses. You might recognize that language from the old Bruner test. They may also include any efforts that you made to apply for a federal loan consolidation, respond to outreach from a loan servicer or collector, or otherwise engage meaningful with a third party that you believed would have assisted you in managing your student loan debt. And this particular person, this particular borrower, their response was, just when I thought I was in track, I landed a job for a little over almost $27 per hour. And then their grandson was involved in a car accident. This person had to go to the hospital and take custody. This grandson is now 1.5 years old. And the son is incarcerated, and they don't believe that the mom is getting custody back of the child. So we have a grandparent who is now sole custodian of someone who's 1.5 years old. She's making nearly $27 an hour. And because of all this, she is not able to repay her student loans. She was actually terminated. I don't know the details of why she was terminated, but apparently she's no longer making $27 an hour. But even if she was, the fact remains, with the cost of inflation and with all the different expenses, you may not have money left over to repay a considerable amount towards your student loan debt. And so when that event happens as a grandparent, there's no future runway, no career to try to make more money. The gig economy doesn't really work. And if there are extra things that someone can do to generate income, a lot of times medical expenses might take that up. And so ideally, someone probably is now in a position to file bankruptcy on that student loan. I mentioned the Bruner test a moment ago. The Bruner test still exists. It's basically a very difficult standard. I used to work for the other side in opposing discharges. I got student loans in law school and in undergrad. I felt folks should repay their loans. Back then, the system worked. Nowadays, it doesn't work as well as it used to. And in fact, the last decade or 2 decades have been absolutely atrocious in some of the things that we see out there. But the fact remains that folks can now file a discharge even under the Bruner standard, because the new rules that came out in November allow for the Department of Ed and the Department of Justice to look over an attestation that has questions just like what I had. And it's a rather lengthy document. Also, someone has to usually consolidate their loans to be a federal direct loan before they file a bankruptcy so that this law will apply. And then they have to do the bankruptcy, and they also have to do an adversary process within the bankruptcy, which is a separate piece of litigation. There's a lot of attorneys who probably won't want to do that. Hopefully there'll be many. We did an ABI seminar. That's American Bankruptcy Institute seminar for folks that were interested in this. So we had nearly 200 attendees. Now, these were all attorneys around the nation that wanted to look into adding the ability to discharge federal student loans to their practice, to their bankruptcies. And so if you are in this position, I think it's probably best to have an attorney. You can, like anything, you can do it all on your own. You can file your own bankruptcy, you can file your own adversary process, you can serve the relevant parties, you can file, file the I'm sorry, you don't actually file the attestation. You send it to your local AUSA, that's Assistant U.S. Attorney. And you can do all that, but it's complicated. It's more complicated than a lot of things. And so if you have the means, I would probably, suggest that you hire an attorney to do that for you. Hopefully in your state, you have someone that is willing to do that. If you do have a bankruptcy attorney, you're in another state, perhaps we can offer advice to that attorney on what to do in a student loan discharge. We're located in Tampa, Florida. We handle cases within the Tampa Bay area. There's 8 or 9 counties around us that we regularly do bankruptcy work for. We are now filing these discharge cases. We have filed a lot of discharge cases in the past for private student loans because the test is very different and somewhat difficult for a private lender to prove that they are a qualified education loan. But now we're doing it for federal loans. So if you have federal loans, please don't think bankruptcy is not an option. When I wrote the chapter for this book that comes out the end of July, bankruptcy was not an option. This particular process was not passed until November. So we didn't cover it at all in the book. And in fact, I read back through what I had said in there because it'd been a while since I'd submitted it. And I even say that, what is it I say? It's kind of funny. Bankruptcy is usually not a way out. And in fact, it actually is now that this new DOJ attestation process exists. So if you have questions, the best way to reach us is by phone, 813-258-2808. Also by email at info@ChristieArkovich.com. And we are more than happy to talk with you during a consultation about the filing of a bankruptcy as well as the filing of this adversary action to discharge your student loan debt. So hope you all have a great day, and please don't ignore the possibility that bankruptcy may be a solution for you. It's never been in the past, but things are different now. Thank you. All right, have a great day.